사발면 끓여 먹어도
Better remind 10 minutes to record. That's a good idea.
할아버지 막 이거좀 같이
Well, good morning, everybody.
Morning. 정말 11시에 나오고
매주
맥주리가 가끔씩 맘대로
10시 11시 이렇게 이거 할리를 바꿔도 되나? 스케줄 바꿔서 이거 지울 수 있잖아.
좀 그걸
He's going to show up today.
어,
Oh, I'm not muted. Yes, she asked, right? That we
학교는 안 하잖아.
talk about contingencies today.
뭘 듣지? 또안 해봤지.
Christine Hahn, are you out there? I don't see you. Christine asked for today's subject matter, by the way.
I didn't come in.
She might be coming in.
Morning.
Oh, hi, Debbie.
Hiding. Do I have a minute to get some tea?
You do. You do. Not 10 o'clock yet.
Contacts and data for just $64. That's not per line, that's total. That's how the average family is saving over $800.
Okay, let's see her. Good morning, Ella.
Good morning to you.
How are you?
Good, thank you.
Hi, Ruth, Cheryl,
Let's see.
Owen. Ollie could be in the office. Samantha. James, are
morning,
you actually
everyone.
listening?
I don't have good lighting. Oh,
Yes, Richard, I'm actually listening.
Okay. That same sarcasm coming through, James. Always good to hear your voice. Oh, Jeff Dreyer gracing us with his presence. What's the occasion, Jeff? He'll never come back now, right?
I guess he's not listening.
He's I agree with you. He can't be listening. Yeah.
Oh, yeah, he just typed something. It's
Oh,
it's
yeah,
John's
yeah.
birthday.
Yes. It is John Fasola's birthday today, everybody. Thanks for pointing that out, Jeff.
So you just go to all forms and type in. Oh. Yes. Yeah.
So did anybody win money on the Super Bowl over the weekend? I did.
How much did you win?
Netted $320
Oh, nice.
on, yeah, first quarter. Actually, I'm not the one who chose the squares. My wife chose the squares. Every time I choose, I lose. So I spent 80 to win 400. So pretty good. It was a fun day. Carlos had a bet with Mike Dunn. Carlos won $100 from Mike. He came in and paid up today.
Yeah, just leave it like that. Thanks. Just crack it.
Good morning, Mary.
Good morning.
And we're just waiting on Debbie. She's making tea.
Oh, it's a tea kind of day.
It is a
Out there.
tea kind of day. So John's on the line now. You can all wish him a happy birthday.
Yeah.
Yeah.
Happy birthday, John.
Thank you.
Over San Diego.
It's fine. That's great.
What is other balloons?
Birthday, John.
Nice balloons, John.
Now, the private company's contract was set to expire
That's
last.
kind of a sophisticated kind of look, Carlos. Good choice.
Oh, thanks.
Yeah.
Carlos said he had nothing to do with them.
Department for renewing contracts.
A mature look.
It is a mature look.
A mature
Hmm.
bow
I
move.
just thought the leopard, right? Yeah.
Yeah, that's funny. All right. Debbie must be standing at the water cooler. Well, good morning, everybody. How are you today? So today's discussion was based upon a request. And that's why we're talking about contingencies and contingency removal. Plus, we always get questions about it, so we thought we would address it. I thought it was a good topic. So a few of the key questions that we included in the notification regarding today's meeting. What happens when the buyer doesn't remove a contingency in writing at the end of the contingency period? What can a seller do if at the end of the contingency period, the buyer doesn't remove the contingency in writing? What happens if a buyer removes all the contingencies and then discovers a material defect in the property prior to the close of escrow and wants to cancel? And what exactly is the rule for cancellation based upon the inspection contingency? And also, is a buyer guaranteed to get the deposit back when the buyer properly cancels a contract in good faith? So we're going to answer all of those questions. So what does the contingency do for us? It actually gives us the ability to condition performance. That's what it's doing. So for example, a buyer could condition performance in a real estate purchase contract based upon the outcome of the buyer's inspection. So if at the end of the contingency period, the buyer is dissatisfied, they can cancel the contract without being a breach of contract. So another condition associated with the contingency would be a maximum interest rate when you're completing the purchase contract. Remember, you're representing a buyer. Be sure to insert a maximum interest rate. And then also, just in regards, not just that, but then the loan contingency is a condition. Once again, if the buyer can't get the loan and when acting in good faith, they have a valid reason for cancellation. You can actually add your own contingencies. You can make it contingent upon attorney review if you'd like. Also, other contingencies that we dealt with years ago, short sale contingencies, that's another one. It would be contingent upon all short sale lenders' approval, for example. Or a seller in today's market may make or condition a sale based upon finding an acceptable replacement residence. So other common contingencies, the inspection contingency, right? And the default time frame for removal of the inspection contingency is 17 days. And can a buyer waive the inspection contingency? The answer is yes. There's no California law that prohibits a buyer from waiving, right? But even though the buyer waives the inspection contingency, that does not preclude you of the obligation to inspect properties. And remember, that's residential 1 to 4 units. That is your obligation to conduct a diligent visual inspection. And then, is there a loan contingency? Well, yes, there is.
And then
So
Zoom
keep in
meeting.
mind. Okay. So can the buyer get a loan? Yes or no? It's a condition of the contract, assuming the buyer does not waive the loan contingency. And then the appraisal contingency, the default response in the contract is that there is an appraisal contingency. There's a box to the right of that which allows you to waive the appraisal contingency. And of course, if the value doesn't come in, can the buyer cancel in good faith and theoretically be entitled to a return of their deposit? The answer is yes. Okay, so a question for everybody. I want somebody to answer this for me. So let's assume the value of the property comes in, but the square footage is dramatically different than the square footage reported on the MLS, for example. Is it a valid reason to cancel based upon the appraisal contingency?
Yes.
No, it's not. Right. So, the appraisal contingency is simply value. The other aspects of the appraisal do not allow a buyer to cancel based upon the appraisal contingency. Now, that very well may fall under the inspection or investigation contingency, but you can see just how critical it is. If we're canceling, we may not necessarily specify an actual reason, but we're going to be specifying areas within the contract upon which we're canceling. Appraisal contingency is very clear. So we always make sure that the reasons we're using are in good faith, and we don't have to disclose the reasons, by the way. So other contingencies, for example, in the RPA, contingency on the sale of the buyer's property, right? A buyer would be submitting Form COP, approval of the common interest development disclosures. That's a contingency. Inspection reports. It could be pest control, septic wells, disclosure of insurability to buyer, preliminary title reports, and then review of the sex offender database. Does anybody ever have any clients that review Megan's Law or the sex offender database? It's scary. If you look at it, you've got neighbors that somehow have been convicted. So take a look at it. I think it's a good idea for everybody's safety and their own knowledge. Then non-optional contingencies, the lead-based paint contingency. So inherent within every contract and statutorily required, if the property is a pre-1978 property, there's a 10-day opportunity to inspect for lead-based paint. Now, you can have that waived if the buyer has the ability to conduct their inspection before a purchase contract is submitted. Keep that in mind. And then the TDS. The seller must give the buyer the TDS and give the buyer the right to cancel within 3 days or 5 days if mailed or delivered electronically. So if the seller doesn't give the buyer the TDS, the California court has held that a buyer does not have to go through the sales transaction. So it is really not it is a non-optional disclosure. There are exemptions, however. We'll go into that at the moment in time. But there's case law, as a matter of fact, in regards to the power of the TDS. Individual occupied a property in excess of 2 years. It was a mixed-use property. Seller never gave the TDS to the buyer, and the buyer probably knew more about the property than the seller, and it gave the ability to the buyer to cancel without being a breach of contract. So it's that important to provide the TDS. Can you close a transaction even though you haven't provided a TDS and you're not exempt? Yes, you can.
There's a question.
There's a question. Okay. So if the square footage comes in different from the listing info, what options does the buyer have? Well, if the square footage does come in different, then it's a question. Remember, it is an agent's statutory obligation to put correct information into a listing. And if found in violation, it's a Civil Code 1088 violation. So if the information or the square footage comes in differently, I think before you have released contingencies, it's probably a valid reason for termination of the contract. I thought it was getting 2,500 square feet and a house is 2,000 square feet. Now, if it's a 50 or 100 square foot difference, it might be a different story based upon the materiality.
But if you've already removed the inspection contingency, then you can't cancel the.
You probably can't, right, have a good faith and reason. Now, it does, I guess the question would be, we see that on the MLS. Remember, there's different methods in which a seller discloses that in the assessor's records, their estimate, you can have it taped or an appraisal. So if the seller's found to intentionally being deceitful, of course, here we are in a fight again, then you theoretically could get your deposit back. Okay. And then offers submitted with no contingencies. Is that possible? It is absolutely possible. The only actual way to remove all contingencies is to submit all seller disclosures in advance of the buyer submitting a purchase contract. Very difficult to do.
And typically you have so much time to review it, but if you receive the disclosures and then
submit an offer
the following day, removing all contingencies, then
for example, the TDS right to terminate or rescind is no longer valid if it's delivered before the contract is submitted.
So timeframes don't matter after that.
So the timeframes don't
days.
matter after that, exactly. Now, if there's a subsequent seller disclosure that's not discovered through a third-party report, it could be a valid reason for a buyer to cancel. Let's see, does anyone have any short sales? Probably not. I'll pass on that one at this moment. And then what about contingency removal? The contract, the RPA, requires active removal of the contingency, and it specifies specifically you must use the contingency removal form. So don't use other forms when removing contingencies. Use the form specified in the contract. It eliminates any question whether removal is valid or not valid. So keep that in mind. And in certain commercial contracts, like the AIR form of purchase contract, has passive removal of contingencies. Most of us aren't going to deal with that. However, in that specific case, it's just with the passage of time that contingencies expire. So remember, you can submit an offer, removing contingencies, and to the right of section L3, there's a box that references the contingency removal form. And then you can check the appropriate boxes on that contingency removal form when you're attempting to make your offer appear better than all the competition. And then what about removing contingencies regarding disclosures that a buyer has not yet received? Buyer has no obligation to remove those contingencies until they receive the seller mandated disclosures. So the initial time frame of the purchase contract for the seller to deliver all disclosures is 7 days after acceptance. So theoretically, the buyer has the greater of the contingency period, or 5 days following receipt, assuming that receipt occurred after the initial 7 days. So you don't have to remove contingencies unless the sellers complied with their contractual obligation. So we've had agents asking our agents or demanding that they remove contingencies, but they haven't sent disclosures. So everybody thinks it's valid here. And then we talked about the contingency period is going to be the greater of the contingency period specified in the contract, or 5 days following receipt of the disclosures. Is that applicable to a preliminary title report? Yeah, it's no different. Seller has an obligation to deliver that. As a matter of fact, there's been some case law in the past in which an agent represented both parties, and the agent failed to deliver the preliminary title report, and of course, that agent then becomes subject of litigation. So it is your obligation to be sure that these seller disclosures are delivered. Now, yes, we rely on escrow to do that in many cases, but it's your obligation as the agent. is if there is litigation, guess who's going to be named? Richard, yeah. And then if the buyer doesn't remove a contingency after the expiration of the contingency period, let's assume all disclosures were delivered. So what takes place? Well, the contingency lives on. And until the seller delivers a notice to perform, forcing the removal of the contingency lives on. And then remember, the default time frame when delivering a notice to perform is 2 days in the purchase contract. So when you deliver a notice to perform, don't say that the buyer must remove contingencies in 2 days unless you have modified the contract. Delivery of that notice to perform would be defective. You have to start all over, right? And then how soon can a seller provide a notice to perform, or either party, let's put it that way, no sooner than 2 days prior to the expiration of the contingency, right? Somebody's.
I'm sorry, can you just repeat what you said just before this? About not telling the buyer they have to perform within 2 days?
In terms of delivering a notice to perform, the contract specifies that the buyer is given 2 days following receipt of a notice to perform to remove that applicable contingency. So sometimes I see a notice to perform and the contract hasn't been modified. They send a notice to perform out and say you must remove contingencies in 24 hours or 1 day. That is considered defective. It has no bearing on the transaction, nor does it create an obligation for the buyer to remove that contingency at that point in time. Let's see. And then in terms of conducting inspections, contingency removal for the inspection contingency and the time frame in which the buyer has the ability to conduct inspections are independent of each other, actually. So the contract specifies the buyer has no more than 17 days to conduct inspections, although the seller could grant additional time or access to the property if they so desire. And then is closing escrow contingency of the purchase contract? Anybody? The answer is no, it is not a contingency. It is a contractual covenant or condition. So if either party doesn't close escrow as agreed, we never send a notice to perform. We would send a demand to close escrow. That would be the appropriate delivery. And the contract specifically calls out a demand to close escrow. And if you deliver a notice to perform, it very well could be defective notice. So let's not put ourselves in those positions once again. And then what happens if a buyer removes all contingencies and then discovers a material defect in the property prior to the close of escrow? Anybody want to answer that one for me? Well, let's assume they've discovered a material defect. It may or may not be a good faith reason for the buyer to cancel and recover their deposit. So one possibility is that the seller was aware of the defect and didn't disclose it to the buyer. That could be a breach of the seller's obligation to disclose material facts and to answer truthfully. So with that in mind, the buyer, even after removing contingencies and assuming it's a seller disclosure, very well could cancel without being a breach. So what if the seller is aware of a defect and then the buyer becomes aware of that defect through a third-party report? That is not a valid reason. It does not open up the rescission period if the buyer becomes aware of that defect after contingencies have been removed, even though the seller did not disclose it. So third-party reports does not give the buyer the opportunity to cancel subsequent to removing contingencies. It would be a seller disclosure. Could be an email, from the agent representing the seller, as a matter of fact. And then what if there's a big hole in the driveway, 10 feet wide, and the seller didn't disclose it? Well, is that a valid reason for the buyer to cancel? No, because it's visually apparent to everybody. Extreme example, I know. I didn't have any better examples, so I thought I would use something like that. But I think sometimes we see cracks in the driveway, cracks in the garage, and unless it's covered, it's probably visible. I would never be remiss in regards to not stating something like that. And then can a buyer cancel a purchase agreement on the basis of an open contingency? Absolutely. Does a contingency give a buyer an unlimited right to cancel? And the answer is no. It must be based upon a good faith reason. So let's assume, for example, the buyer did not remove their loan contingency, and the buyer can get the loan, and the buyer cancels based upon the loan contingency. It's probably not a good faith cancellation, and they're subject to losing their deposit. And then also, what if the buyer causes their own breach? They don't deliver bank statements to the lender. They're not cooperating. Then once again, that would be causing the failure of their own contingency and not a valid reason for cancellation. 70 cancels based upon the loan contingency. We're going to want to see the formal declination from the lender so we can evaluate the reasons for cancellation or whether it was a valid good faith cancellation. We talked about the appraisal, but once again, the appraisal is considered an opinion of value, so it doesn't fall under the buyer's obligation to provide that to the seller. However, if the buyer cancels based upon the appraisal, then yes, contractually, if it's specified in the current contract, the buyer has an obligation to provide the seller with a copy of that appraisal. So be careful in regards to cancellation, value only, other aspects of the appraisal probably would fall under a different contingency. And then also, let's assume maybe someone's playing games and they're the highest bidder in the property and they're awarded the purchase contract. And then the agent for that buyer meets the appraiser at the property and tells the appraiser, gives them all this information to come in with a negative conclusion, something less than the purchase price. Do you think then that would be a valid reason for the buyer to cancel or even renegotiate the purchase price? Highly unlikely. Does anyone representing buyers typically attend appraisals? Can you see anyone's face in there? Raise a hand. Just wondering. Keep that in mind if you're representing the buyer and you go to meet the appraiser and have the intention of causing them to come in with a lower valuation. Want to get involved in that? Nothing surprises me. It just seems like there are so many variations in regards to what buyers are doing now. They do anything they can to be awarded the purchase contract with never the intent to perform based upon what they agreed to. So they're always looking for something or repairs. They're negotiating.
As a listing agent, I definitely offered some comps to the appraiser.
Oh yeah, I would agree. You're a listing agent, especially now. I think it's so hard to justify some of the values, but I think for the most part, we're seeing more appraisals coming in than we are those failing, which is very interesting to me. If somebody has a different story, please let me know. Yeah. And a couple of other things in regards to the loan contingency. When the buyer specifies that they're going to pay $1 million and they're putting 20% down, remember, if the buyer pursues financing for only 10% down and fails to obtain the loan, they virtually cannot cancel based upon the loan contingency. So let's assume it's the opposite end of the spectrum and they decide, I want to pursue a loan with 30% down. Maybe they qualify for the loan, but maybe because they have insufficient reserves, they can't actually get the loan. Is that a valid reason for cancellation because they pursued a loan whose loan to value was less than what was specified in the contract? I would argue no. They could have caused their own breach by not having sufficient reserves and claiming they're going to put 30% down. So qualify or tell your buyers, if they're going to specify financing in the contract, which many do, be sure that they pursue the financing that's specified in the contract, so we don't put them in an awkward position. If they choose to do it against your advice, and that's at their discretion. And then in the financing section, be sure to always put a maximum interest rate in there, and we have an inclining interest rate market. So it's probably more important now than it was a year ago. Then a couple of other things. If a buyer is approved for a loan, but for some odd reason there's some unusual specifications or criteria of the loan, a prepayment penalty, that may very well be a reason to cancel because the terms that are traditionally associated with a loan that most buyers obtain are not a part of that offer. I don't think we see that too often. I can't remember anyone closing an adjustable with a prepayment penalty now for years. It must be out there though. And then the rules for cancellation based upon the inspection contingency. Well, keep in mind, the buyer has a wide latitude to exercise cancellation rights based upon the investigation or inspection contingency. I would suggest that if they're ever going to cancel, they probably should have a couple of good faith reasons. It's always best, and we never tell the reason. We specify the paragraph in canceling. Because at some point in time, we may have to be prepared to give that, but we have no obligation initially now. And I see listing agents pressing agents, and you should never respond to them. Say, this is what the buyer told me, and leave it at that. You don't have to go any farther. And then let's see. And yeah, once again, for canceling on the inspection contingency, it could be, let's assume that the pest control inspection report indicates there's termite damage, but the seller is willing to repair it. Is it a valid reason for the buyer to cancel? Yes, it can be. So they don't like termites, they don't like bugs. It doesn't matter if you're going to remedy the situation or not, but that very well could be a valid reason. If the roof is in disrepair, even if the seller is willing to repair that, it still can be a valid reason for the buyer to cancel. And then the very last question, is the buyer guaranteed to get the deposit back when he or she properly canceled the contract in good faith based on the contingencies? No, the buyer is never assured that they're going to get their money back, and we're always subject to someone else's discretion. So there could be an argument maybe that, what if your client is just not credible, is a liar, and they're in front of a judge and the judge just doesn't like them? Well, the judge has broad discretion. Also, small claims judge, they're not known to know real estate law. So they very well could rule in the other party's favor. So we always want to reduce our risk, but also let's never tell them that they're guaranteed of obtaining their good faith deposit. So that's the end of my presentation. Do we have any specific questions that maybe we can answer or respond to? Well, I see our blank faces, tired.
I have the forms up. Did you want to?
We do have the forms up?
Yeah.
Sure. Let me see if I can see it now. Is there any question about serving a notice to perform versus just sending a contingency removal form? Remember, to invoke or to cause the clock to start ticking, simply delivering a contingency removal form to the other party is insufficient. You must send a notice to buyer to perform. And remember, it's not anything that's required by statute, but it's just a contractual requirement that those are the steps that you must take when sending notice.
Question for you. So when you take out inspection contingency in your, when you have your inspection contingency in your offer, is HOA part of your inspection contingency, or is it just like your home inspection report?
I think that's a good question. I think anything related to the common interest disclosures would be separate and distinct from the investigation contingency itself.
So then when you're taking out loan and appraisal, just left inspection contingency, HOA docs are not delivered, you still cannot give them a contingency.
You have no obligation to remove that contingency, correct?
But even if inspection is separate from HOA, you're saying I still cannot give them the inspection contingency removal?
You can, yes. I'm sorry if maybe I didn't understand, but yes, because they're two separate contingencies, you can remove the investigation contingency. However, that is certainly the most broad contingency benefiting the buyer, whereas it's going to be much more narrow based upon the common interest disclosures. I'll give you an example for the common interest disclosures. Maybe, is parking available for somebody with a 30-foot truck? Well, your investigation may not uncover something like that, However, the common interest disclosures, the rules and regulations should address that. So I would suggest that that would fall under the contingency for the common interest disclosures, separate from the investigation. Does that answer your question, Shweta? No. So parking in my example will not fall under the investigation contingency. It could.
I get what your HOA stuff is, but when you're removing all contingencies except inspection contingency in your offer, is HOA automatically removed?
If you remove it, no, it's not automatically removed. No,
It's
no,
not.
it's a separate contingency. The HOA contingency is separate and distinct from the investigation. As a matter of fact, it is section 2F on the contingency removal form.
I see it on the contingency removal form, but I'm talking about the offer, the purchase offer.
Okay, so if you check the box, all buyer contingencies, if you choose to remove all, could the buyer have an argument that you never provided me with the disclosures? Maybe. I don't think it's a very good argument. The only reason, if you submitted an offer saying all contingencies were removed, the only valid reason for termination would be the rescission aspect once receiving the TDS. Now, I still don't know if I answered your question. I didn't. Let's start over.
That's okay, doesn't matter.
No, it does matter.
We want to know.
Yeah, we have other people that want to know. Come on, Shweta, don't give up yet.
So like, when you're submitting an offer, you take out loan contingency, then you take out appraisal contingency. So I'm not looking at the contingency, I'm not looking at the contingency removal form, I'm looking at the purchase offer. So
I
I
see
see
what you're
Carlos
saying.
has your thing going down. So when you go down further to the next page, so you see over here, you have appraisal, no appraisal contingency, no loan contingency, and investigation of property as 10 days. So does that, and there's nothing in the information, there's nothing else filled out. So when I just have 10 days out there, does HOA docs, is HOA part of that contingency or not a part of that contingency?
Well, I think in the purchase contract, the HOA is separate and distinct.
Common interest.
Yeah, it's separate and distinct, so it's called out separately.
So if nothing is filled out, if they haven't filled out anything here, it still lies there.
Yes, yes,
Okay.
I believe so.
Okay.
And
so
then, in terms of, I think when people on their counter offers, they write, no, remove the loan contingency. Well, is that kind of like, what's the definition of is? Remove the loan contingency, does that mean it's removed? I think there's all these specific arguments, that we just need to clarify when doing whatever we're doing. Now we're submitting the offer, we can see the box, no loan contingency, no appraisal contingency. So just be careful of the language of any counter offers or addendums that you read and review to be sure that the language is explicit in regards to what we're doing.
Can I ask a question back to what Shweta was asking?
Sure.
It's a good question, Shweta. If I put in an offer and I mark no loan contingency, no appraisal contingency, and I put investigation of property 0 days and acceptance, but I leave everything else, solar documents, blah, 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 at 17 days, let's just say, you're saying that I can still cancel the contract and get the EMD back for one of those reasons if it was a good faith reason.
For the investigation, if we say 0 days.
Let's say for HOA docs, L6.
Yes.
L6? Yes. Okay.
Yes. Because you did not remove that specific contingency.
I see. Or if there was an issue about solar panels that came up later on, L7.
That's a separate contingency also.
It's still there. Okay.
It's still there. Correct.
Thank you.
So yeah, L7, review of leased or lien items. It's mentioned solar panels, for example, PACE and Hero loans. And then keep PACE and Hero loans course, we always have real life examples. So just recently, going back for a transaction in May of last year that we represented the seller on, well, the buyer claimed that it was never disclosed to them that there was an existing encumbrance on the property, and the lender missed it also, and it was a hero loan, as a matter of fact. So hero loans or PACE loans, they're disclosed in various areas. You should find it on the NHD report, first of all. You should also see it on the preliminary title report. It may not be necessarily really clear to you. And then also, the seller property questionnaire asks the same question. Now, fortunately, in all three cases, we had the necessary disclosures. And so you can bet in this specific case, this would be the liability of the agent representing the buyer in regards to what's taking place. And then the lender, probably what the lender's doing is those loans become a superior lien against the property. The lender for the buyer can now call that loan due and payable. So be very careful about that type of financing. You need to look at the property tax bill and the preliminary title report and NHD report to see if there's a hero loan. If it's a traditional lease or lien associated with solar panels, which usually they will always subordinate, that's far indifferent, as a matter of fact. So it's a much more clear disclosure to any subsequent buyer. But PACE or hero loans, maybe not as apparent.
So what was the outcome?
Well, that's a good question right now. We've responded indicating we provided them with all the disclosures that they received and signed. So I think the agent is now trying to address the issue with the buyer. Because the buyer is trying to refinance, and my guess is the reason's trying,
That's
the buyer's,
what they probably found out, right?
yes, the buyer's probably trying to refinance. The lender finally discovered that they can't sell a loan. They probably sold it, then it was audited, and then Fannie Mae found out that now they're subordinate to this hero loan. So they're sending it back to the lender on a buyback.
So they should sue the lender.
But while the lender is going to be in violation of their lending covenant with whomever the bank is that provides them the warehouse line. So there's a lot of implications. Then they're going to go back to the broker and put a demand on the broker to say, buy this loan back, or we're going to sue you, right? And then they make the same demand on the buyer too. And the buyer really had no idea. Well, the buyer should have, right?
I had a question.
Yes.
Okay. When you have a FHA or BA and they sold the property as is, they have to comply with FHA and BA, how the property will be at least to be sold like that. So when you're going to the contingencies, even though they say as is, as you're able to hold in the contingencies, or you have to automatically get out?
Well, let's take it a step farther. Let's assume it's a buyer that's using FHA financing, and the buyer checks the box indicating that there's no appraisal contingency. Well, the contract calls out that any FHA or VA financing is subject to an amendatory clause, which must be included in the contract. So even submitting the offer saying no appraisal contingency doesn't really remove the appraisal contingency for the buyer who's obtaining FHA or VA financing. That purchase price must come in at or greater than the agreed, the appraised value must equal or exceed the purchase price in a purchase contract. And then in reference to your comment about repairs, if the lender calls out any repairs, it's incumbent upon the seller to correct those deficiencies. Otherwise, the loan's going to fail and the buyer's entitled to walk away without any repercussions. And remember that a mandatory clause for the appraised value, the buyer can keep that seller in escrow through the day of close of escrow. There's nothing the seller can do. So they've got a lot of ability to hold a seller at bay. It's unfortunate. I hope I answered that question. I had a hard time with Shweta.
Sorry about that.
Well, Gina was interested. That's okay.
Thank God for Gina.
I'm gonna work on my responses to make sure I'm clear. Any other questions? No? Well, thanks for coming, everybody. Be sure to wish John a happy birthday.
Happy
And then
birthday,
it will-
John.
Happy
Yeah,
birthday.
happy birthday, John.
Happy
birthday,
birthday,
John.
John.
Thank you, everybody.
John is welcoming any gifts that you'd like to send. All right, have a nice day, everybody.
Today.
Okay.